Hi, this is David Brannen coming to you with another video. Today I'm going to talk about what medical information is your employer allowed to know about you as someone who's dealing with a disability and trying to reintegrate back into the workforce. So after watching this video, you'll have a better sense of what medical information your employer is entitled to know about you and what your right to privacy is. Now, if you like this video, hit the like button. Don't forget to subscribe and leave us those questions because we love to answer the questions. What information is your employer allowed to know about you from a medical standpoint? What medical information are they allowed to know that you suffer from a certain medical condition, what your symptoms are, what your treatment is, this type of thing? The answer to this is a resounding no. And the courts have been very clear on this, that the right to privacy of medical information is very high. The employer is only ever able to know the bare minimum amount of knowledge about your medical situation or limitations as they need to meet their own duties to you as an employer. So let me give you an example. Employers have a duty to accommodate you if you have a disability that needs accommodation in the workplace. For example, let's say an accommodation I needed was I could only work on screens certain periods of day because it would give me migraine headaches or something like that. So an accommodation might be that they would set things up so that I could work maybe paper-based or off the screen doing other duties or something like that. If they were going to make that type of accommodation for me, they would need to know that I had a condition that was such that I can only work on screens X amount of hours a day, and then they could then go about, they don't even have to know what the condition is necessarily, but that's one of the legitimate limitations of the condition. So the way this is handled is where employers get into trouble here is where they overstep and try to get too much information or more information than the minimal amount that they need. What they're entitled to know is what are the accommodations that you need, what are the limitations you have, or what are the limitations that are imposed on your ability to do the employment, so that the employer then can figure out how are we going to accommodate this person? Is it possible for us to accommodate this person? That's kind of the starting point. It's minimal, minimal, minimal. The employer is not allowed to know everything. They're not allowed to snoop around. So people get kind of nervous about this when you're dealing with a disability claim because the employer will hire people who do learn a lot about your medical information. And that's kind of how employers make sure that they protect your rights. So what employers will do is they will hire outside agencies who maybe will manage the disability claim, or who rehabilitation type workers who will kind of act as a go-between between the employer and you. So the rehabilitation person working on behalf of the employer will know all about your situation. They will then report back the bare minimum details to the employer, and the employer can have some confidence knowing this is all legit because I have my own person looking at it, who is a registered medical person who has duties of confidentiality to you and things like that. So if your employer sends you to their own doctor, again, they're not necessarily entitled to see the whole doctor's report. They're entitled to some conclusions maybe that come out of the report. It's a very touchy situation that they're not entitled to a whole lot of information. It's the bare minimum information. That's what the courts are always looking at. What is the bare minimum they would need to meet their duties to you as an employer and either accommodating you or making sure that it's a safe workplace for you and other people. If you're asked to sign any type of authorization forms or disclosure forms, sometimes you'll sign these forms and they're very broad and you may be giving them the rights to know all this. So be careful of what you sign. If you don't sign over the rights for them to see this information, they don't have it. The starting point is they're allowed to know very little information. If they've overstepped those bounds, there's some penalties and things there that you can look into, but I would encourage you to be reasonable about it and realize that there can be sometimes mistakes that are happened that are in good faith. People weren't ill intent. But if you think that people have done it on a with the idea that they're kind of out to get you, then that may be a time to speak with a lawyer to see if there's anything that can be done about it or if you want to pursue it in any way. That's all for now. I hope you enjoy this video and we'll see you back here next time.